This short video is a continuation of my discussion of the expert strategies in the deposition setting. It begins with some of the lawyer's strategies, followed by strategies that the expert can employ to properly defend herself in the battleground of the deposition. The opposing lawyer would like to get the witness to make a statement or give an answer that harms the witness's position and helps the deposing lawyer's position. From the opposing lawyer's perspective, the most effective response from an expert witness is a concise, simple answer, ideally an unqualified yes or no, to a question that presents a fact or assumption in favor of the deposing lawyer's argument. A clear, simple deposition answer to a precise question is the most effective response that can be used against the expert at trial. This is very important for the witness to understand and to try to avoid succumbing to this trap. It's obviously something of a failure or a loss if the expert witness gives the lawyer that answer. But if the perfect question is asked, the truthful answer must be given, even if it's harmful to the expert's opinion. Let me cover some specific strategies and tactics for the expert. 1. Always stay calm, but be particularly mindful of your calm attitude if the emotional heat in the room increases. In my experience, the more emotional the opposing lawyer becomes, the less substance he has to bring to the table. In fact, I am more concerned about the calm, quiet plodder who just keeps looking for more information than I am about the lawyer who is yelling at me. 2. Protect yourself. If you get into a difficult situation that you don't know how to resolve, make sure you make a record that properly states your position. Where this sometimes occurs is where your client's lawyer instructs you not to answer a question. In fact, that instruction should rarely be given, but it happens frequently. The only time it's appropriate is if the question seeks to violate a legal privilege, but legal privileges rarely apply to the work of a designated expert. So if the instruction is given, it's probably wrong. But then the witness is put on the spot. The opposing lawyer is grilling you. Are you going to follow this erroneous instruction? Does this lawyer represent you? Now the witness is between a rock and a hard place. As a practical matter, you're going to follow your client's lawyer's instruction and refuse to answer the question. But in response to this aggressive cross-examination, first, stay calm. But don't hesitate to make a record saying that you are unsure of what to do, but that you're acting in good faith, and of course, if a judge ordered you to answer the question, you certainly would. Make a record that shows your professionalism. Recognize that you have rights as a witness, and it's your deposition. You are the one testifying under penalty of perjury. 3. Remember that the only result of the deposition is a written transcript. The transcript doesn't show the emotion of the moment or the tone of your voice. 4. Don't let the opposing lawyer interrupt your answer. Sometimes the deposing attorney doesn't like your answer, and in that situation, you're not telling her what she wants to hear. The lawyer may interrupt you with another question or try to cut you off. If that occurs, politely state on the record that you're not finished with your answer and you'd appreciate not being interrupted. Of course, you can only do this if you're answering the question asked and not rambling on and on. 5. Personal questions are not really appropriate, but the attorneys have a lot of latitude in inquiring of the expert witness. A proper question only has to be designed to lead to relevant evidence. However, remember, your client's lawyer doesn't really care if you're being exploited. He's only interested in protecting the client. Here are some examples of slightly relevant questions that lawyers will use to exploit you a bit. You should be aware of them. Did you consume any alcohol in the last 24 hours? Well, that general question is not really appropriate. It's close, though. It is appropriate to ask you if you have consumed any alcohol or taken any drugs that would have any effect on your ability to testify today. So if I'm asked if I have had a drink or taken any drugs, my answer would not just be a yes or a no. it would be, I haven't taken any drugs or any alcohol that would have any effect on my ability to testify today. Another question that is often asked is, what do you think about the opposing expert witness? Or, do you know of Dr. Smith's reputation in the community? These are tempting questions to answer, but they shouldn't be answered. Why? Because they are no-win questions. First of all, you're not an expert in reputations or what you think of somebody, so the questions are outside of your area of expertise. Also, they are no-win questions, because if you say Dr. Smith is a great guy, you'll hear that answer in front of the jury in trial. If you say Dr. Smith is a hack, you'll never hear it again. So when I'm asked that question, I very carefully state that I know Dr. Smith, but it's not my place or my area of expertise to comment on his reputation. If pressed, I continue to state that my refusal to directly answer that question should not be negatively interpreted for Dr. Smith. I just don't have an opinion on that question. I'll sometimes use the following example. Mr. Jones, I have an opinion about your tie, but it's not appropriate for me to state that opinion in this deposition and have it considered to be expert opinion testimony, because I'm not an expert in ties any more than I'm an expert in other people's reputations or whether they are good guys or bad guys. A good response to a question that you believe is completely irrelevant is, if you can tell me what relevant evidence that question might lead to, I'll gladly answer it. Questions like, where were you born? Where did you serve in the military? Or were you in the military? Do not really seek to find relevant evidence and are therefore not appropriate. My purpose in discussing these personal type questions is providing the expert with an awareness of the degrees of control in the expert deposition. Some lawyers will begin to push the envelope to gain control of the proceeding. I suggest that the competent expert witness politely push back on these overreaches. As you can see, this has only been an excerpt from my longer video series, The Art of Expert Witness Testimony. You really need to look at that series to understand the expert's role in giving effective expert depositions.
Brian Peter Brinig is an adjunct professor at the University of San Diego School of Law and managing director of the forensic consulting group of CBIZ, a national financial services firm. The strategies and tactics presented in this video presentation are discussed in complete detail in his treatise, Mastering the Art of Expert Witness Testimony, which is available by scanning the QR code on the screen or on Amazon.